Honorable Swart, I believe you are ready to take us forward.
Thank you, Chair. I make this submission on behalf of, as a member of the committee, but as a member of the ACDP, but if I understand correctly, it is as a member of the committee. It is important to note that I have been here since 1999, and I just want to make a general observation firstly that during the land hearings, I was deeply moved by the plight of all people that addressed us, from all poor people, from farmers, everything. And I had a deep sense of pain that many people are experiencing in our nation, of fear, of anxiety on the one hand, and of hope on the other hand. And so I make these observations, firstly, in addition to the written submission that we made as a party, which was, is available, and secondly, as a member of the party. Firstly, the document has been provided, but I would like to just speak to it. I'm not going to read through the document that was circulated to all members, but at the outset, I just want to express my concern in the manner in which the written submissions have been dealt with, and I refer to Section 59 of the Constitution, which sets out the process for public participation that must be engaged with. I remind the committee that this committee issued an invitation for written submissions in May, and in addition to the written submissions, people were invited to make oral hearings, and the duty of public participation has been set out in the Constitutional Court, in the Doctors for Life International versus Speak of the National Assembly, which sets out the guidelines to how written submissions should be considered. And Chair, I'm concerned that the committee, as I've argued before, did not consider the written submissions. Is it, did you want to say? Chair, may I continue?
I'm just sending someone to check if we are required for voting.
Would you note my time? Thank you, Chair.
You can carry on, Honorable Swart.
Okay. Chairperson, in my view, it's not sufficient to allow opportunity for members to go and look at the written submissions. We as the committee should have considered the written submissions to be compliant with Section 59 of the Constitution and the obligations set out in the Doctors for Life matter. And this, I believe, is a serious issue. I believe that we have not complied with our constitutional obligations in this regard, and I'm welcome to engage further with deliberations, but that is my key point in limine at the beginning. But Chair, I appreciate that the issue of land reform, which is restitution, redistribution, and land tenure is a complex and very emotive issue in our nation, going back many, many years. And Chair, I would submit, and I associate myself with the views expressed by many believers, many churches, that we should be informed, and I've said this in Parliament, that whilst there's a need for justice, there's a need for reconciliation, nation building, we are called for love, we are called to be peacemakers in our nation. And as leaders, Chair, we need to find common ground amongst ourselves, that we can be united to find solutions to this issue, that will promote harmony and social cohesion, that we can take our nation forward. And I'm encouraged by the widespread commitment that we had observed during the oral hearings of people that are genuinely trying to find solutions to this issue. And I mentioned this in Parliament, where I commended the Deputy President for what happened in Bella Bella, where farmers came together with the department, and there was really a presence of God seeking solutions for this issue, Chair, and I want to commend that. But Chair, in essence, I want to say that, as has been set out, that any possible review of Section 25 must consider the impact on food security, stability in the agricultural sector and the economy, on investor confidence, financial exposure to banks and other financial institutions by commercial farmers, as well as resulting in adequate support for emerging farmers. And these are some of the factors that are set out. And we appreciate that there are differing views on the application of Section 25. We as a party have said that we do not support expropriation of land without compensation. We also believe that Section 25 does not present an impediment to land transformation. And that this view was very well argued by former Constitutional Court Judge Albie Sachs, and is also the view of the high-level panel on the assessment of key legislation, the Motlanthe report. And Chair, it is very important to bear in mind that the South African Human Rights Commission which is the custodian of the Bill of Rights, they stated unequivocally in their submission that while they regard the possibility of expropriation of land without compensation, they said the Constitution does not lend itself to such amendments that are needed for expropriation without compensation in this context. And they add, Chair, that if we were to amend the Constitution in this basis, it would be premature and would conflict with the doctrine of subsidiarity, which means you first have to pass subordinate legislation before you amend the Constitution. There were various views on title deeds, on state custodianship of property. We reject that, Chair. We believe there should be title deeds. We do not accept state custodianship of property. We are opposed to calls for even churches' property to be taken. That we reject. We believe title deeds should be given so that wealth can be explored, so that small businesses can be explored. And of course, farmers need that collateral to raise funds and to raise capital for, they need property. Chair, a lot of mention was made to the Motlanthe panel report. This has not been considered. They've made very good submissions there. They held public hearings, and we need to look at that. We also need to look at inaccuracies in existing land orders. So, Chair, shortly, my recommendations, I think I've got about 2.5 minutes left. How much do I have, Chair? 2 minutes. Yeah. The ACDP recommends, because of the differing views on the exact parameters of Section 25, that we as Parliament approach the Constitutional Court to give guidance and parameters on the exact parameters of Section 25, whether reduced compensation is permissible as presently worded, and even the extreme possibility of no compensation could be allowed as presently formulated. We believe that Section 80 of the Constitution allows for Parliament to approach the Constitutional Court. Let the court give guidelines in that regard. Let them give a judgment to us. Secondly, the Motlanthe report panel, we support restitution based on compensation, Chair. Let us also look at land audits. Let us look at beneficiaries of land restitution and redistribution projects given title deeds. Let's look at the interests of commercial farmers balancing with emerging farmers. And Chair, we are very concerned about the large numbers of illegal land invasions that have taken place. We believe we as a committee must express ourselves very strong in that regard. So, Chair, lastly, let us just focus on what the High Panel report said. The report said, experts advise that the need to pay compensation is not the most serious constraint on land reform in South Africa to date. Other constraints, including increasing evidence of corruption by officials, the diversion of land reform budget to elites, the lack of political will, and the lack of training and capacity have proved far more serious stumbling blocks to land reform than the issue of compensation, Chair. So let us encourage existing farmers, and we as the ACDP, we oppose any amendment to Section 25 to allow for the expropriation of land without compensation. Thank you, Chairperson.
Thank you very much, Honorable Swart.